Good day! I'm Mary Grace Galanida from BSHM3A, and I am going to tackle today the Chapter 2 of the Legal Aspects in Tourism and Hospitality, the Philippine Institution. According to Dr. Amparo Santos, it is the right of every Filipino to travel. Traveling is one of the most enriching experiences in life. It allows one to discover new places, interesting people, and novel ideas. So here are our learning objectives. First, identify important provisions in the Philippine constitutions related to tourism and travel. Next is to enumerate the rights of the travelers as well as the entities engaged in the entire tourism, travel, and hospitality industry. What is constitution? Constitution is defined as the original and fundamental principles of law by which a system of government is created and according to which a country is governed. It is the fundamental law of the land to which all other laws must conform. It is written instrument by which the fundamental powers of the government are established, limited, and defined, and by which whose power are distributed among several departments for their safe and useful exercise for the benefits of the body politic. So the Article 3 or Bill of Rights and Article 12 or National Economy and Patrimony are some of the constitutional provisions related to tourism which may be given preferential attention. And now let's proceed to the Bill of Rights. In Section 1, no person shall be deprived of life, liberty, and property without due process of law, nor shall any person be denied the equal protection of the law. So, under the Constitution, the term life means more than mere existence and includes the right to the decent living. According to Justice Malcolm, liberty refers to the freedom to use one's abilities and make lawful choices, while property encompasses anything of value that can be owned or exchanged. Equal protection of the law means that individuals in similar situations should be treated equally, without favoritism. Due process of law ensures fair treatment, includes notice the opportunity to defend oneself, and a fair of impartial trial. So consider a situation where a person is facing a legal proceeding. They have the right to a fair trial and should be given notice of the proceedings against them. They should also have the opportunity to present their case, defend themselves, and have the reasonable chance to prepare their defense. So this ensures that their rights to life, liberty, and property are protected. For instance, if someone is accused of a crime, they have a right to be treated fairly and not be deprived of their freedom without proper legal procedures. They should have the opportunity to engage in a lawful activities such as choosing where to live and work, pursuing a chosen profession, and entering into a contract that are necessary for their livelihood. In Section 3, Number 1, the privacy of communication and correspondence shall be inviolable except upon lawful order of the court or when public safety or order requires otherwise as prescribed by law. Number 2, any evidence obtained in violation of this or the preceding section shall be inadmissible for any purposes in any proceeding. So, this provision covers various forms of communications such as letters, telegrams, telephone calls, and messages. Republic Act Number 4200, also known as Anti-Wiretapping Law, imposes penalty for those violating the privacy of communication. Section 13 of the Act allows court to authorize wiretaps in certain crimes related to national security. Any evidence obtained unlawfully is considered fruit from the poisonous tree and cannot be used as evidence in administrative or criminal proceedings. In Section 4, no law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people peaceably to assemble the petition of the government for redress of grievances. So, speech, expression, and press encompasses all forms of communication, including oral, recorded, such as tapes, CDs, and DVDs, and written mediums. Obscenity refers to the materials that, as a whole, appeal to prurient interest and lack serious value in literature, art, politics, or science. Such materials are not protected under the free speech guaranteed of the Constitution. To determine obscenity, certain criteria must be met, including appealing to the prurient interest, depicting offensive sexual conduct prohibited by law, and lacking serious value. So in section 6, the liberty of abode and of changing the same within the limits prescribed by law shall not be impaired except upon lawful order of the court. Neither shall the right to travel be impaired except in the interest of national security, public safety, and the public health as may be provided by law. So this constitutional provision guarantees two freedoms. First is the freedom to choose and change one place of residence and dwelling place. And next is the freedom to travel within or outside the country. However, these freedom are not absolute right and cannot be regulated by a lawful court order. For example, an order granting bail to a person accused of a crime is considered a lawful court order, and a hold departure order may be issued to ensure that the person's appearance when required. In Section 8, it is stated that the right of the people, including those employed in the public and private sectors, to form unions, associations, or societies for purposes not contrary to law shall not be abridged. So, government employees now have the right to form unions, but they do not have the constitutional right to strike. Unlike private sector employees, government employees are prohibited from striking based on the civil service rules and regulations. So let's imagine a scenario where government employees, such as those working for a government agency, decide to form a union to collectively represent their interests and negotiate for better working conditions. They have a right to form this union and engage in activities such as collectively bargaining. However, unlike employees in the private sector who may have the right to strike as a means of protest, government employees are not allowed to go on strike. This is because civil service rules and regulations prohibit government employees from striking. The case of Social Security System Employees Association et al. Versus the Court of Appeals et al. In 1989 established these principles. So the tourism, travel, and hospitality industry makes use of a lot of contracts like employment, engagements, agencies, sales, franchise, property management, purchase, services, and the like. Thus, it is important to study obligations and contracts. So in section 10, no law impairing the obligation of contract shall be passed. So under the Civil Code, a contract serves as a law between the parties involved, as long as it does not violate any law or public policy. The court ensures that the parties adhere to the terms of the legal contract. However, if a law changes the terms of the legal contract or interferes with the conditions, it impairs the contract's obligation and is considered null and void. It is illegal to interfere with the terms of a legal contract through legislation. And now let's proceed to the national economy and patrimony. In Section 10, the Congress shall, upon recommendation of the economic and planning agencies, when the national interest dictates, reserves to citizens of the Philippines or to corporations or associations at least 60% of those capital is owned by such citizens, or such higher percentage as Congress may be prescribed certain areas of investments. So, in the grant of rights, privileges, and concessions covering national economy and patrimony, the state shall give preference to qualified Filipinos. The state shall regulate and exercise authority over foreign investments within its national jurisdiction and in accordance with its national goals and priorities. So, the provision allowing the nationalization of certain businesses related to the national economy and patrimony is not a new concept. In the case of Ichong versus Hernandez, it was established that the Filipinization of businesses can be done without violating the Equal Protection Clause. So the term patrimony refers to both the natural resources and cultural heritage of the Philippines. It encompasses not only the land, forest, and mines, but also the intellectual and artistic abilities of the Filipino people. When the Constitution mentioned qualified Filipinos, it means that preference should be given to citizens who can contribute effectively to the common good due to their credible competence and efficiency. This provision does not mandate preferential treatment for incompetent or inefficient Filipino citizen or organization. The goal is to choose individuals or entities that can make a positive impact for the benefit of the country. In Section 11, no franchise, certificate, or any form of authorization for the operation of a public utility shall be granted except to citizens of the Philippines, or to corporations or associations organized under the laws of the Philippines, or at least 60% of whose capital is owned by such citizens, nor shall franchise, certificate, or authorization be exclusive in the character or for a longer period than 50 years. Neither shall any such franchise or right be granted except under the condition that it shall be subject to amendment, alteration, or repeal by the Congress when the common good so required. So imagine a situation where a company wants to operate a public utility such as transportation service or a power distribution network. According to Section 11, the franchise to operate this public utility can only be granted to Filipino citizen or corporation with at least 60% Filipino ownership. The franchise cannot be exclusive and has a maximum duration of 50 years. The Congress has a power to amend or repeal this franchise if it is in the best interest of the common good. And in terms of participation, the state encourages the general public to have a strike in public utilities. Foreign investors can be part of the governing body, such as the board of directors, but their participation is limited to their proportionate share in the capital of the utility. However, it is important to note that the executive and managing officers of the public utility must be a Filipino citizen. This provision ensures that the public utilities are operated with the welfare of the Filipino people in mind, and in the ownership of the management of these utilities are primarily in the hands of Filipino citizens. So in section 14, the sustained development of the reservoir of the national talents consisting of Filipino scientists, entrepreneurs, professionals, managers, high-level technical manpower, and skilled workers and craftsmen in all fields shall be promoted by the state. The state shall encourage appropriate technology and regulate its transfer for the national benefits. The practice of all professions in the Philippines shall be limited to Filipino citizens, save in cases prescribed by law. So, if a foreign individual wishes to work in the Philippines, they must obtain a working visa from the Bureau of Immigration and a working permit from the Department of Labor and Employment. This ensures that Filipino talents are given priority for employment opportunity in the country, while still allowing for the possibility of employing foreign individuals in specific cases of industries. So that ends with my discussion. Thank you and have a good day.